Alright, ebusian for mamda mu na masi emfambra ye channel yiso. Medo bibiasi ediba ye channel yiso. Na masel say notification button ehun hia me ye pa obetene ne on. Say the updates bebia onso nsa be den e be ka no ahwe. Na bibia aye kama. Say the news e mu hwam na ye de ba mu. E brentima nyibre. Yenkotie ensem kakra ekoso.
Listening, please. Let me even roll back a little bit. So we had a council meeting on the 27th of March after we had met the Chief Justice to have our annual meeting with the Chief Justice. And at that meeting, one of the agenda items which we quickly, in fact, it came more as AOB, was the matter that was unfolding before us. As at that time, the Chief Justice had indicated that she had not received the petitions. So at the meeting, the council decided that we should assure the Chief Justice that the bar was going to be alive to its responsibilities, and therefore we would want cooperation and to ensure that we were kept abreast with whatever was taking place. That was March 27th. The next day by 9 a.m., March 28th, the executive of the bar met with the Chief Justice, and we conveyed to her the sentiments of the bar, because it is part of our constitution to uphold the freedom and justice delivery system, as well as to maintain the independence of the judiciary. Now, as it were, there was a lull in terms of information flow, till we were informed that the warrant for her suspension had been delivered to her. Immediately we were told that the warrant had been delivered to her, we convened an emergency executive meeting. And at that meeting, the executive decided that a statement was to be written. However, since the executive acts on behalf of the entire council, it was necessary that the council should also be brought into the picture. Members, this is part of our democracy as a bar. We act through our executives that we have elected. And the statement that was put together, comments were received from 2 p.m. when we started the meeting to after 10 p.m. Bearing in mind that as at that time, nobody had any idea what was in the petition or response. So this statement went back and forth and back and forth and back and forth and back and forth. And early the next day, it had to move. It was then that we got to know that information in relation to the petitions were out there for people to read, as well as her responses. No one had come out from official circles to say that what we were reading was not official. So as far as we are concerned, we are coming from rightful sources. Now, as at the time that we had the executive meeting, which cascaded into the council meeting, we were aware that the entire bar will be meeting this Saturday. We were fully aware. In fact, there was even a suggestion that we even put it in as a paragraph. But as I said, back and forth and back and forth. So this is the forum that even though we are here as your leaders, you speak to us. And it is just by divine providence that such a forum was meeting so close to such an important matter. So you have spoken as the bar. And this conference is a conference which we put on the calendar of the Ghana Bar Association since December 2024. The entire council is aware of this date that we are going to have a mid-year conference. It was supposed to be preceded by a bench bar faculty lectures. Bench bar faculty lectures. However, because of happenings, we had to move straight into the mid-year conference. So you are in a good space. I know one speaker was, in a way, even though he wasn't with us, his words seemed to sum up bits and pieces of what took place. But you are here. This is the time for us to pick the collective view of the bar by virtue of resolution. So you would have heard in my opening speech that there are issues that we have to look at. For instance, the guidelines, we can't run away from it. Whether this proceeds or not, this was a judgment that was in 2020. 2020, the end of the year passed, 2021, 2022, 2023, 2024. And if we hadn't been hit by this, 2025, the guidelines were not going to come out. And that is why in my speech I said it's about time that the Ghana Bar Association spearheads it. I know someone mentioned the Attorney General. But we can spearhead it because we are there for the independence of the judiciary. And so members, what we are saying is that let us couch what we believe to be the voice of the bar. And that voice will go out as the statement of the bar. We are here to pass resolutions. Someone can start with the couching of the resolution so that there are seconders and so on and so forth, because we have said enough to show the direction in which we want to go as a bar. And so if one person can approach us and then the person starts and then we couch this resolution and then we act accordingly.
I reiterate, my position has been that there is no basis whatsoever for finding a prima facie case in respect of at least the three petitions that have come. And I'll go on to explain why. Can the president do something wrong in accordance with Article 146? Absolutely yes, because the whole purpose of Article 146 is guided by the Constitution generally and by the very provision of Article 146. Now we see the suspension, and need I say that Clause 10 of Article 146 permits by way of discretion, the exercise of discretion for the president to exercise this discretion to suspend the Chief Justice. And constitutionally, the exercise of discretion is again measured by the very Constitution in itself, Article 296, as elaborated in the plethora of cases by the Supreme Court. And so can the president vote? Yes, he can, in the exercise of discretion, where it is contrary to the very provisions of the Constitution. Now, coming to the very fact of this case, my position has been that there was no basis for the exercise of the discretion. And I'll say again, that first of all, if the only communication to the Chief Justice indicates without more that I have established a prima facie case in respect of the 3 petitions. The question is, will that alone suffice under the test under Article 296? I do not think so. Second, we look at the basis of these 3 petitions in substance to determine that even if on the face of it a prima facie case may be made. Again, I do not think so. And I'll come back to it. Some, if you look at the petition of this Savior Group or so, where the thrust of the petition is on 2 fronts. The first being that the Chief Justice recommended to the President, giving some reasons why the number of justices in the Supreme Court should be wide, it should be more. And then you say that that is a ground for petition for removal. Practice, as you are aware, is that the appointment of justices all throughout go through a process, including consultation with GBA, Judicial Council, etc. In any case, that letter that the Chief Justice wrote was a mere recommendation. We know the import of recommendation or even advice to the President. It is not binding on the President. Indeed, it shows that the President did not even proceed to act on that advice of the Chief Justice. And so for me, I find it questionable how such points stated by the Savior Group can present a ground for the establishment of a prima case. Second, and most importantly perhaps, is that the thrust of the petition of the group is that the Chief Justice, while sitting as a panel member of the Supreme Court, and you and I know that the Supreme Court's jurisdiction, unless it is a single justice of the Supreme Court acting on behalf of the Supreme Court, usually is not fewer than 5 justices of the Supreme Court. And so if the basis of the petition, which then ends up in the final of a prima facie case, is that the CJ, who has 1 vote, just like all the other 4 judges on the panel, while sitting as a court, made certain decisions, gave certain orders that you are not satisfied with, the ground for it, I believe, is not Article 146. And I've always maintained that the Constitution and our laws in themselves present avenues for challenging decisions of the court. Now, I always tell people that I'll draw your attention to the very deep statement made by then Professor Justice Dateba in the Judicial case. Now, if you remember, there was a preliminary objection raised by one of the parties that this is a dispute in respect of a petition to remove the Chief Justice. So how can the Chief Justice himself, then Chief Justice Akwa, empanel the member to determine this matter? And Justice Dateba said something, and I admonish all Ghanaians to take a careful look and reflect on that statement. Indeed, he said, and I quote, that we, the rest of the judges at the Supreme Court, are not malleable clay in the hands of the Chief Justice. In other words, we have our independent thinking. We have our own, as it were, objectivity. So to suggest that we will be influenced by mere reason of the paneling of the Chief Justice is unfortunate. And I do agree with him. And so for the petition to suggest that the Chief Justice, as part of the panel, as part of the court, made certain decisions, with all respect, is an insult to the rest of the justices that sat on the panel with him. In other words, they were so malleable that some of the decisions, which were unanimous, they were controlled by the Honorable Chief Justice. And I do not think that is a fair statement to make against the other justices of the Supreme Court. In any case, if you are dissatisfied with that decision where the Chief Justice presided, there are avenues for expressing that dissatisfaction. And secondly, when the Chief Justice sits as part of a panel, she could even be part of the minority. She could express a dissenting opinion. It is a decision, it is the order of the court. It is not a decision of the Torkonoo. It is, and again, let me go back. I don't like to even use personalities when it comes to issues of the judiciary. Especially, I mean, something is so coincidental that the first time I appeared on the show Newsfile was in respect of matters on the judiciary, and have been consistent that in as much as we have the right to criticize, to be dissatisfied with decisions of the court, we have to be careful about not destroying the very tenets of our democracy. Because the judiciary continues, even on 6th January, when all the other arms of government are giving way after election to other other parties or government to come into power. And so let's be very careful. And so to say that a decision of a court and not a decision of Torkonoo is a basis for establishment of a prima facie case, I'm afraid I do not agree to that. You look at the other petition by Daniel Fori. He did at paragraph 5 of Daniel Fori's petition. He says boldly, and I quote, that I am not required to produce any evidence to support any of the allegations I have made in this petition. And that is a basis. In fact, we saw that, but for the request by the CJ for copies of this petition to even assist the court in determining these mere allegations, bare assertions that were made by Daniel Fori in his petition, do we say suffices for establishing a prima facie case? I do not agree so. Again, in the same petition, we are looking certain things that are including the exercise of some administrative functions without proof. And so something might fear, and that should be the fear of every Ghanaian, that somebody puts pen to paper, makes bare assertions, mere allegations against you, and that suffices as a basis for prima facie case. I believe we are lowering the threshold for the exercise of that constitutional process to remove no mean a person, but the head of another arm of government, which is the judiciary. Similar arguments can be made with respect to the Apollo Ayamda case. Again, and he is the only one that attaches a newspaper item to his petition. And go and check that newspaper reportage of Law Platform at that time. He said it is only Torkonoo who arrested, who caused for his arrest. Again, sitting as a panel. And in that same exhibit, which he attached to his petition, you will find that the newspaper reported that even Justice Mahama made interventions to him and said that you cannot be this discourteous to the court. You cannot be this violent to the court. In other words, your act, as it is now, is being in contempt of the court. And we do not see any of the judges signing to say that they did not agree with what happened that day. And so something, I'm saying that I'm not being dismissive. If you have a grievance, if you have any dissatisfaction with any act of any judge, more so the Chief Justice, I'm not saying that we are gagging you from expressing that dissatisfaction, but I'm saying that our very constitution and the laws we have given to ourselves provide specific avenues for addressing these grievances and dissatisfaction. If you are saying that the processes are not efficient, that is a different matter. Okay. And again, let me emphasize before I conclude on this that please